Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about when a revocable trust becomes irrevocable. All right, so we get questions all the time, both in our office, on our website, as comments to these YouTube videos, on LinkedIn. We get questions all the time about the difference between a revocable trust and an irrevocable trust. And I'd say generally, the concept of an irrevocable trust scares people. Irrevocable sounds fixed, can't change it, locked in, not flexible. So let's take a look at some of the common forms of trust and discuss this whole revocable, irrevocable concept. Okay, so there are many, many different kinds of trusts out there. I think that's one misconception that the public has, is that there's really only one or maybe one or two kinds of trust, but trusts are designed for many, many different reasons. And all trusts are either revocable or irrevocable. Now, let's take a look at maybe the most common uses for trusts and discuss that whole revocable, irrevocable concept. All right, so best way to do that is to give an example. Let's say Tommy is single and, he's maybe 60 years old and he has a couple of daughters and he wants to arrange his affairs. He wants to arrange his estate so that, things that he owns, his house, his investments, maybe even a business, he wants to make it as easy as he can, so that when he passes away, his two daughters kind of immediately get everything without going through any difficulty. So Tommy looks into it and he sees and thinks that, the way I'm going to do that, the way I'm going to set up my estate, Tommy says, to avoid all the court and attorney involvement of probate, is I'm going to set up a revocable living trust. So he does that. He not only sets up his revocable living trust, but he goes through the process, perhaps with the help of attorneys or others, to retitle those assets that, if they were in his name when he died, they'd be frozen and the survivors would have to go through court and attorney involved probate process to get access to them. So Tommy retitles those assets into his trust, his home, his investment account, his business. And the idea is when Tommy dies, he names perhaps his daughters as the co-trustees of Tommy's trust when Tommy dies, and he names his daughters as the beneficiaries, equal beneficiaries of Tommy's trust when Tommy dies. So Tommy sets all that up, and some of the revocable, irrevocable provisions are, while Tommy's alive, Tommy's living trust is revocable. In fact, it's called a revocable living trust. So as long as Tommy's alive, he can change it, he can undo it, he can change who gets it when he dies, he can change who the trustees are, he can revoke it, take all the assets out of the trust and put them back in his name if he wants to. He doesn't do that, but he could if he wanted to. So Tommy likes that flexibility. However, Tommy's revocable living trust further states that when Tommy dies, at the moment of Tommy's death, Tommy's trust becomes irrevocable. And that initially kind of scares Tommy. He's like, I don't like that irrevocable concept. But if you think about it, if Tommy's trust was allowed to be revoked or amended after Tommy dies by someone, then they could defeat whoever had that ability to revoke it, could change all of Tommy's wishes regarding who gets the trust assets when he dies, who's going to be in charge of all of that. So it actually makes sense that Tommy's trust, while revocable while he's alive, becomes irrevocable when he dies. Now let me add one little layer of complexity to the equation. Let's look at the married couple situation. Sammy and Sally are married. They also want to arrange their affairs, but they're married, and so they want to arrange their affairs so that when one of them passes away, things are really simple for the surviving spouse. And then they also want to arrange it so that after they both pass away, things are easy for their two daughters, and they'd like to avoid all the court and attorney involvement in probate that you hear so much about. So Sammy and Sally set up the Sammy and Sally Revocable Living Trust. But Sammy and Sally have some additional concerns because they're married. Sammy says that, look, if Sammy says, if I pass away first, I want to make, all of my portion of the trust, because Sammy and Sally, we own things 50-50. Sammy says, when I pass away, I want to make my portion of the trust available for Sally. She might need it. But I want to make sure that when Sally later passes away, then my portion of the trust, Sammy says, must go back to my two daughters at that time. I don't want Sally to be able to change that in case she gets, crazy or whatever. So when Sammy and Sally set up their revocable living trust, they arrange it so while they're both alive, they can revoke, they can change anything, they can undo it, they can change who gets it when they die, they can change who's in charge of it when they die. However, the Sammy and Sally Revocable Living Trust says that when one of them dies, and let's say Sammy dies first, then the portion of the trust attributable to that deceased spouse becomes irrevocable. Now you might think that might scare Sally as the surviving spouse. Now there's this trust that's irrevocable. Well, Sammy's portion of the trust needs to be irrevocable once Sammy dies to protect his children from Sally trying to give away Sammy's portion or leave Sammy's portion to someone's other than Sammy's two children. So typically what would happen is the Sammy and Sally Revocable Living Trust directs that when one spouse dies, the assets get divided into what I'll call the Sammy Trust and the Sally Trust. Sally's still alive. The Sally Trust is revocable, and that still contains 1/2 of the trust assets. But the Sammy Trust, when Sammy dies, that Sammy and Sally Revocable Living Trust got split up into two trusts, the Sammy Trust and the Sally Trust. The Sammy Trust, now that Sammy died, is irrevocable. But you know what? That's okay to Sally because perhaps Sally is the trustee of the Sammy Trust. Perhaps Sally is the income beneficiary of the Sammy Trust, so Sally gets all the income that the Sammy Trust produces. Perhaps Sally, as the trustee, has the discretion to be able to make distributions from the Sammy Trust to Sally for her health, education, maintenance, and support, the typical HIMSS standard. But what Sally can't change is the fact that when Sally dies, the Sammy Trust must revert back to Sammy's two daughters. And perhaps it's already set up so that when Sally dies, the Sally Trust goes to the two daughters as well, but Sally would have the right to change that after Sammy died because Sally's portion of the trust remains revocable. Okay, so that irrevocable component that takes place when one spouse dies really protects the ultimate beneficiaries of that first spouse to die. So that's where you see many revocable trusts becoming irrevocable at a later date. Now, there are some other reasons why trusts are set up to be irrevocable from the get-go, from the very creation of the trust. And you see that because people, in order to gain certain benefits, they have to relinquish certain control. And so by transferring assets to an irrevocable trust, they've minimized their control or eliminated, in many cases, control over those assets so they get certain benefits. Benefits like removing assets from the estate for estate tax purposes, arranging assets so they would not have to be consumed in the event someone went into a nursing home in the future, they could qualify for Medicaid. And then sometimes people set up irrevocable trusts from the get-go for some type of lawsuit protection or creditor protection. So that's a different animal. That's where people set up irrevocable trusts that are irrevocable from the moment those trusts are inked. But in virtually every kind of revocable living trust scenario, there is a point in time, typically at someone's death, where that trust does become irrevocable. Okay, hope that helps. We'll see you next time.